Hi, welcome back to Morbid Sunshine. I just got a new document from the Idaho 4 case. It's a document to do with the call logs, and I thought I would do some details. I'll read the document out, and I'll do some details tomorrow. Some sort of plan out, right? Comes now to the state of Idaho by through Letha County prosecuting attorney and respectfully moves the court for an order to remain allowing the state to admit the text messages from DM on November 13th, 2022 and the testimony from DM and BF regarding their conversations with each other on the 13th of November 2022. The phone records were discovered on a hard drive DM iPhone extraction provided on April 5th, 2023. So they didn't get it from Bethany's phone, they got it from Dylan's phone. Exhibit 18 from the grand jury record states Exhibit S1. Attached testimony of DM and BF was provided to the defence as part of the grand jury record. State Exhibit S2 and State Exhibit S3 attached. Standard admissibility. In general, testimony that is hearsay is excludable at trial. IRE 802. However, there are exceptions to the rule. Two firmly rooted exceptions are Idaho Rule of Evidence, present sense impression. A statement describing and explaining an event or a condition made while or immediately after the declarant perceived it. Idaho Rule Evidence 803-2, excited utterance, a statement relating to a startling event or condition made while declarant was under the stress of excitement that it caused. The requirements of the federal version of the present sense impression and excited utterance are best stated. There are three principles requirements which must be set before hearsay evidence may be admitted as a present sense of impression. 1. A declarant must have personally perceived the event described. 2. A declaration must be an explanation or description of an event rather than a narration. And 3. The declaration and the event described must be contemporaneous. The requirements for hearsay statements to constitute an excited utterance are 1. Startling accusation. 2. A statement relating to the circumstances of the startling accusation. 3. A declarant who appears to have had opportunity to observe personally the events. And 4. A statement made before there have been time to reflect and fabricate. Both exceptions require that the declarant personally perceives the event or the condition about which the statement is made. In addition, both have temporal limitations with limit admissibility, ID, under the present sense of impression exception. The declaration must be substantially contemporaneous with the event in question. The fundamental premise underlying the present sense impression. State's motion in limine Text messages and testimony continue. Exception is that substantial contemporary of the event and statement minimalizes unrelatability due to the declarant's defective recollection or conscious fabrication. Courts have given broader temporal limitations for excited utterance. Court appeals held that although in most cases the startling event which prompts spontaneous exclamation are accidents, assaults, and the like, there is no reason to restrict the exception to those situations. Limits victim statements. He killed me. He killed me. After being shown a photograph approximately 8 weeks after attack held admissible. Some courts have admitted excited utterance made well after the event, when declarant was suddenly subjected to rekindled excitement, because events may so deeply traumatize a person that long after stress has subsided, a chance reminder may have enormous psychological impact, causing renewed stress and excitement, inducing utterance relating to the original trauma. There is no requirement within the language of IRE 8031 that the declarant be excited or emotionally affected by the event or condition in order to fall within the present sense exception, but if so, then the statement can overlap with excited utterance exception, holding that statements were admissible under present sense impression and excited utterance exceptions to the hearsay rule. Arguments. DM's phone records contained an Exhibit S1 for November 13, 2002, and BF testimonies contained exhibits as to what DM told her should be allowed at trial. Okay. In the case at bar, starring on November 13, 2002, DM sends a text message to E.G. Uber driver to inquire if he is driving. The state submits this text message exchange is not hearsay because it will not be offered for truth of the matter asserted, i.e. e.g. driving status. Instead, it would be offered to show a timeline for the night, i.e. DM was awake and texting at 2:10 from 12:19 to 12:21, 50 DM. Attempts to call BF. So she was awake texting at 2, but from that doesn't. So was she awake between the hours of that time? I don't know what that means. DM attempted to call BF, Xana Condell, and Glenn Kylie Congreves, and Madison Morgan, all calls unanswered. The records of these calls are not hearsay, as they each do not meet the definition of statements. Oral assertion, written assertion of non-verbal conduct intended as an assertion under the rule. From 4:22 to 4:24, DM and BF Send the following text messages. DM to BF. No one is answering. DM to BF. I'm really confused, RN. DM to Goncliffe Kylie. DM to Goncliffe, what's going on? BF to DM, you do, what the fuck? BF to DM, Xana was wearing all black. DM to BF, I'm freaking out. DM to BF, no, it looks like a ski mask almost. BF to DM, shut the fuck up. BF to DM, actually. DM to BF, like he had something over his. Like he had something over his head, over his forehead and a little round the mouth. DM to BF, I'm not kidding. Oh, I'm so freaked out. So am I. My phone is going to die, fuck. Come to my room, run down here. How'd she know it's a he? If she thought, hang on. If she right, a friend said, right, a friend said, listen to this. A friend said, Xana was wearing all black. And then she comes back with, DM comes back with, he's like he had something over his head. So she's thinking it's male. And Bethany's thinking it's Xana. DM to BF. I'm not kidding, I'm freaked out. Yeah, okay. All of the book decorations are present sense impression and excited utterance. This is supported by DM's grand jury testimony where she indicates she just witnessed a startling event, heard noises in the residence, saw an unknown male in the residence. The declaration indicates both BF and DM are trying to make sense of the startling event contemporaneously or immediately following the startling event, i.e. no time to reflect or fabricate. CDM Grand Jury Testimony attached, Exhibit SE. At 4:24, DM calls Ethan Chaplin uncle, call unanswered. The phone record, like other records of calls, is not a statement pursuant. DM and BF continue to text at 4:24. DM texts BF, I'm screwed though. I'm screwed though. And BF responds, yeah, I know. Yeah, I know. But it's better than being alone. Again, both statements are admissible as present sense impression and excited utterance as they are describing an event or their state of mind and are spontaneous reactions to that event rather than the result of reflective thought. wonder what must have been going on through the brain. At 4:27 DM, calls gone please, call unanswered. And at 4:28 DM, calls Kernodle at phone call unanswered. These are not statements pursuant. At 4:32, sent a text message. Sent a text message to Goncleve stating, please answer. This statement is present sense impression, shows DM, perception of events, and an excited utterance, a spontaneous reaction to the event rather than the result of reflective thought. The next morning, DM sends the following text messages starting at 10:23. Please answer DM to Goncleve. Please answer DM to Morgan. Are you up? DM to Goncleve. Are you up? These text messages are not hearsay because they will not be introduced for the truth of the matter asserted. Even if deemed hearsay, they are allowable as present sense of impression as they reflect consistently and continuation of DM text messages from the night prior and reflect her then perception of what was then occurring. Example, waking up and realizing that she had not heard from her roommates. At 11:39 DM has a text exchange with her father. BM, these statements are not hearsay. They will not be introduced for the truth of the matter asserted, but instead to show a timeline of the morning. At 11:55, DM receives a text message from J stating bro. This text message will not be introduced for the truth of the matter asserted. At 11:50, DM calls EA. This phone record is not statement pursuant to IRE. DM receives a text message from J at 11:51 and a vandal alert at 1:01. These texts are not hearsay because they will not be introduced for the truth of the matter asserted, but instead show a timeline for the morning. DM and BF testimony contained in State Exhibit S2 and State Exhibit S3. The state anticipates that both DM and BF will testify at trial. The state intends to ask each witness about statements made to them on November 13, 2022. This testimony should substantively replicate the testimony that they provided at the grand jury proceedings. The state submits the statements from both DM and BF to each other are allowable hearsay because they are present sense impressions and or excited utterances. See previous adjustation. Judge, sorry, my reading's terrible. Judge John Judge has previously ruled that, that's such a cool name, ruled that the text messages and statements of DM and BF are present sense impressions and excited utterances, holding both the text messages and the testimony of BF as to what DM had here were admissible as exceptions to the hearsay rule, sealed under denying motion to dismiss. The indictment on grounds biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Page 20, filed. DM, our phone records contained Exhibit S1 for November 13th of 2002, and BF testimony contained Exhibits S2 are allowable in trial under Crawford. Under IRE 803, present sense impressions and excited utterances are admissible whether or not the declarant is available as a witness. Any statement found outside of above the exceptions to hearsay are non-testimonial for purpose of a Crawford analysis. Further, even if somehow deemed testimonial, the Confrontation Clause of the Sixth Amendment does not bar their admission. Finally, we reiterate that when the declarant appears for cross-examination at trial, the Confrontation Clause places no constraints at all on the use of his prior testimonial statements. It is therefore irrelevant that the reliability of some out-of-court statements cannot be replicated, even if the declarant testifies to the same matters in court. The clause does not bar admission of a statement so long as the declarant is present at trial to defend or explain it. I see. The state submits if any of the declaration made are deemed testimonial by both DM and BF will testify at trial anyway. The conclusion. Based on the cited authority, the state respectfully requests the court approval in limine of the admission of text messages from DM on November 13th of 2022 and the testimony of the BF regarding what DM told her in November 13th. Signed respectfully, Ashley Jennings. I hereby certify that true and correct copies of the state's motion and testimony I might be Dylan's signature. Oh, I don't know actually. Aye, that's all I have for this document, but I'll be reading another document out maybe later than in the morning. I just thought I'd post this and hope that's insightful to you to know what state of mind they were in it doesn't really explain much, but a trial, it will explain a lot more. And it makes sense if you give a person time, they could lie and fabricate. This hasn't been the case. I'm confused a bit why they knew it was a he, but he is very tall, and by his height alone, his sheer height, without thinking, in a trauma period of time, she's not realised that. What she realises that it isn't Sana, it's a man, and it must have been frightening. Imagine how frightening these people must have been. And we've only got their testimony about his behaviour, like him calling out, going, "Don't worry, I'm coming to help you soon." It screams, I mean, why would they be involved? What have they got to gain from that? It doesn't make any sense to me. Thanks for listening. Take care. Bye-bye.